It's time for Wild About Trial, where we break down some of the biggest news stories from around the country. And today we're joined by attorneys Misty Marris and Jesse Weber. As always, thanks guys for being here. First up, a couple in Ohio, Micah Risner and his fiancée Nataleigh Schlette, sent pictures of a staged murder scene to family members in hopes of getting their attention and getting them to come home and repay some money they allege was owed to them. Well, as you can imagine, the family didn't think it was fake, and police were called. The pair was arrested and charged with inducing panic and could be facing jail time. Jesse, should they be?
First of all, Chris, wow.
Who does this?
Number one. But yes, when you look at the inducing panic statute, they clearly fall under this. Number one, they had to create a false report of a crime, which here was a murder. And number two, that had to create a serious public inconvenience or alarm. And here, that's when the police had to be called to the fake crime scene, which takes away from their duties as police officers and in protecting the public to go to a staged fake crime scene.
Let's not forget that it wasn't the couple who called the police. So in this particular instance, it's not the couple that caused the public inconvenience or alarm.
That doesn't matter.
In these types of cases, this statute is really reserved for bomb threats, yelling fire in a crowded theater, not putting ketchup in your bathtub.
But Misty, with all due respect, they created a fake crime scene that caused such a panic and terror in the minds of their family members.
Not in the community, just in the family.
Absolutely,
but what happened?
Pranks do that?
But this crossed the line.
By definition?
This crossed the line because police had to be called into a fake crime scene,
so
and they should be handling real problems in the community.
Case.
A family member actually gave advice on how to get rid of the clothes and perhaps get away with the crime.
Well, and that was an interesting twist, Chris. So that maybe shed some light on this woman's character. It was actually the sister of one of the pranksters, but it's not a crime because accomplice liability requires that an underlying crime actually occur. There's no attempt crimes in accomplice liability. So she's free and clear, but I mean, hey, maybe didn't put her in the best light.
At least he knows she's got his back later on in the future.
True.
But
ultimately, what happens?
I think they're going to be found guilty. I think they need to be held accountable for their actions.
When nobody's injured in Ohio, generally this is treated as a misdemeanor. No way there's jail time.
Next up, in Iowa, a family is filing a lawsuit against the Marion County attorney who is threatening to file child pornography charges against a 14-year-old girl. This after the teen sent photos of herself to a boy. And while she's not nude in those pictures, reports are she is showing a lot of skin, one of them in just her underwear. The lawsuit says the photos are no worse than what you'd see in swimsuit ads and that this is a parenting issue and not a legal issue.
You know, if I am representing the Marion County attorney, his argument would be, look, I don't really want to press charges against her. I've offered her another deal. Sign an admission of guilt, go to community service, take classes. This is a way to understand what you did was bad and to deter other people from doing it, because it doesn't just create a problem for her in terms of an embarrassing situation, it creates a dangerous situation in terms of child predators.
Let's take a step back. This girl's the victim. She took a photograph which is protected by the First Amendment, doesn't qualify as child pornography, that was distributed without her consent. These statutes were meant to protect these people.
She could end up on a sexual predator list for the rest of her life.
Yes, that means she can't babysit, she can't be a teacher. When she goes to college, she's gonna have to advise the school that she probably can't live in the dorm, if she even is able to get into a college.
For sending a suggestive photo at the age of 14.
Exactly.
That doesn't seem right.
The big issue is we have a problem where minors send sexually explicit material.
There's no question.
And I think when you look at the Marion County attorney, he's using what tools he has to try and deter this behavior in his community. I think we both can agree he's not
criminal charges.
But that's a great deterrent.
This is a 14-year-old girl in a suggestive but clothed photograph.
The statute requires a certain type of picture to qualify as sexually explicit. This photograph simply does not qualify under the letter of the law.
But then, Misty, we're discussing, you're talking about the definition of nudity, and then we have to have a whole discussion about whether or not those photos constitute partial nudity or not.
But
we're talking about a 14-year-old girl. We're talking about a 14-year-old girl. We're not talking about an adult woman.
So if she took a picture on her vacation with her family at the pool in a bathing suit,
are
you telling me that, and that picture is posted on Facebook, you're telling me we should charge her with a crime?
Misty,
put her on a sex offender registry.
Let's just hope that America is having the same debate right now, and we can teach kids not to
educate your kids. Learn what it means to have those images on the internet. That's absolutely true.
Misty, Jesse, as always, thank you very much for your insight. For more on these cases, you can go to our website or wildabouttrial.com.